In this video, we'll talk about step-parent petition for a green card. When a U.S. citizen marries a foreign national and that foreign national has a child, can that child get a green card as well? Watch this video and I'll tell you more. Hey everybody, and thanks for joining me on another immigration law video here. I'm Jacob Sapochnick. I want to ask you a favor. Make sure you subscribe to this channel and click that bell below to get notified on any new videos that we release every week. I also want you to follow me on Instagram. Those accounts are right here. And make sure that you leave a comment below. Let us know what you think about this video. Ask a question or concern, and I'll try to respond to you as soon as I can. In this video, it's actually an answer that I was giving to a client of mine who was really concerned because he just married a U.S. citizen, and he himself has a child from a previous relationship that he wants to bring with him. And so the question is, yes, it's clear that the U.S. citizen spouse is going to immigrate him as well, right? Because he's marrying her. But what's going to happen to the child who is not her? The child is not the child of the U.S. citizen. What's going to happen to the child? Can that child immigrate as well? Well, the key here is this child is 17 years old. And they just married. So what the law states is that as long as the marriage takes place before the child turns 18, that child can immigrate in the same petition with the foreign national. So the U.S. citizen is going to file an adjustment of status package for the foreign national father and an adjustment of status package for the foreign national child, the daughter in this case, who is 17. Now, if this child was over 18 at the time of the marriage, then they wouldn't be able to join on the same petition. They would have to find another way to immigrate after the parent gets a green card. It's a really important distinction because a lot of people come to the United States, they meet somebody, in many cases they have kids from prior relationship. It is really important to understand those the distinction, because it's not 21, it's 18. 21 is a confusing date because 21 is the date where somebody is considered to be a child for immigration purposes. So for example, if I am a U.S. citizen child and I have a parent that I want to immigrate, I have to be 21 to be able to immigrate my foreign national parent. However, when you have a stepchild, when you have a step-parent situation, in this case, what matters is 18. If the marriage took place before the child turned 18, then that child can immigrate with the parent in the same petition. And in this case, the distinction was that the child was still in the home country. And so what I told this client, as long as their marriage took place before the child turned 18, they're going to be able to bring this child to the United States and immigrate them in the same petition. Now remember, we have a lot of cases where couples are marrying overseas and then they come to the United States to do their adjustment of status. It does not matter where the marriage took place. What matters is that the marriage took place before the child turned 18. So to answer this particular question, in a step-parent situation, it is possible for the U.S. citizen to immigrate the partner who has a child, and in this case the U.S. citizen is going to be a step-parent, and as long as the kid is under 18 before the marriage took place, then it's possible to immigrate. Hopefully you enjoyed this video. Make sure you leave a comment below with a question or suggestion. Also, please subscribe to our channel, click that bell below to get notified when new videos come every week. And we love to read your comments and respond, and we are excited to make new videos with information for your benefits. Thanks for watching, and we'll see you in our next video.